I'm just going to wait a moment to check that the stream is back on. I think it is now.
It's a slight problem in the feed, I think.
Lord Crisp, before lunch and before we go to Lord Jenkins' evidence of the Archer inquiry, you've referred a handful of times to a review in 2007.
Yes.
And really so that others following your evidence can understand what that refers to.
Yeah.
Could we look at WITN 3996025? So this is May 2007, review of documentation relating to the safety of blood products 1970 to 19...
Can we stop?
Yes.
I'm not getting the screens I should. And I think we just need to pause and have the system reset. At the moment, I'm full screen looking at myself. I'd rather look at you. And I can't see any documents, and I can't see Lord Chris.
Fine. We're just sending urgent messages to the technical team to try and resolve that. Do you now have the correct screen, sir?
Not yet. I think Bob is working on it. The technician is working on it. He has access to my screen, so it should be resolved in a moment. I'm very sorry to those who are watching for the slight hiccup. Right, I'm now looking at the review of documentation relating to the safety of blood products, non-A, non-B hepatitis, May 2007.
Good.
Right, thank you. Let's proceed.
So the first point, Lord Crisp, obviously, is this post-dated your time in office.
That's right, yeah.
So it's a review that was undertaken and a report put together after you'd left, and so it didn't have any bearing at the time on either your own thinking or the information that was being provided to you by your officials.
It wouldn't, but I'm sure you understand the reason that I was raising it. Should I expand on?
Yeah, well, if we go to a page in it, and then I think it'll become obvious, and then perhaps you can expand if you want to.
Yeah.
So if we go first of all to page 3, just to see what this is. It says a review commissioned in June 2006, the need to assess the extent and content of documents held by the DH in relation to non-A, non-B hepatitis was prompted by calls for a government-backed public inquiry and the return of documents previously considered missing from a firm of solicitors. The objective of the review is to consider all documents related to non-A, non-B hepatitis held by the Department of Health and report on their content. And then if we see in paragraph 2, the DH became aware that documents relating to the safety of blood products were mislaid/destroyed sometime during the period between 1990 and 1998. The incidents of the mislaid/destroyed DH files were the subject of an internal audit in February 2000. Following publicity of this loss, photocopies of 610 documents were returned in May 2006 to the DH by a private firm of solicitors who'd acted for claimants during earlier HIV litigation. There was also the realisation within the DH that some documents held in unregistered files might be pertinent to the issue of the safety of blood during 1970 and 1985. These unregistered files held 4,629 documents. So that's the background to the review. If we then just go to page 5...
Well, if you just stick on that page and just pick up paragraph 3 as well.
Yes.
It was
presumed
majority.
that the majority of documents from 1975 to 1985 previously identified as missing in paragraph 2 above have been located.
Yeah.
And then if we just go to page 5, paragraph 14 says it was identified that there were 2 instances of documents relating to blood products being inadvertently destroyed or mislaid. And then paragraph 15 deals with the category of documents that we've largely been talking about, Lord Chris.
That's right, yeah.
And then paragraph 16 refers to the ACVSB documents. Now, paragraph 15 then says, in the first instance, large numbers of documents were mislaid following their retrieval for DH solicitors' use in the 1989 HIV litigation. These documents were removed from their original files, provided to counsel. The trial folders were returned to the DH. These mislaid files were the subject of an internal audit review in February 2000. Now, just pausing there, I'm not sure currently whether that's correct, Lord Chris, but I'm not inviting you to comment on that because the 2000 internal audit that I'm aware of dealt with the ACVSB files, which are the subject of paragraph 16. But
no.
I'm not
fair enough.
suggesting that you be able to help with that. It then goes on, the DH was not able to respond to a later request in January 2005 under the Freedom of Information Act for release of documents that were subject to a public interest immunity claim by the DH during the HIV litigation. These missing files, including those subject to PII, are thought to cover the period from 1970 to 1990, although the internal audit report commissioned in February 2000 doesn't specify the number of documents or the period covered by the loss. Then paragraph 16 deals with the ACVSB files, and it said in the last sentence of paragraph 16 that those are outside the scope of this review. So again, that's a little more context about the this document. And then I think if we just go to page 27 and then 29. So picking it up, paragraph 104 repeats what was said about documents having been removed from their registered files. Yeah. Paragraph 106 says, from the review of documents and assessments made, there's little duplication between the documents returned to the DH by a firm of solicitors and those already held at Wellington House. The documents returned by the firm of solicitors are believed, therefore, to be some of the documents previously thought to be mislaid. Now, again, just pausing there, Lord Crisp, and this is really for the benefit of others, a comment from me rather than a question for you. The documents described as returned by the firm of solicitors will not be the Department of Health's originals, which the firm of solicitors would never have held.
Indeed.
They would simply be copies that the solicitors obtained during the HIV litigation disclosure process. So that they don't, they may have helped reconstruct files, but they wouldn't represent the Department of Health's own documents. But then 107 says those documents now held at Wellington House in 102 registered files are thought to be those removed from registered files for use in the HIV litigation in 1985 and previously thought to be destroyed or mislaid. It suggested that the nature of these files was not sufficiently subsequently appreciated as they were no longer stored in registered files and staff and location had changed over time. And then paragraph 109, it's not possible to state that all the documents previously recorded as missing have been located, but a very substantial number relating to the time in question have been and are included in the inventory, and if related to non-A, non-B hepatitis in the review, these documents include those that were subject to a PII claim during the HIV litigation. And then if we go finally to page 29, paragraph 112, it is presumed that the majority of documents previously considered missing, with the exception of the ACVSB files, have now been located. So I think taking this report at its highest, it establishes that a significant number of documents have been located, but not necessarily all. Is that
Indeed,
fair?
Indeed.
It would also tend to suggest that whatever precisely you did or didn't say to Lord Jenkins, the explanation that was being given even to you by your officials was not correct.
Yes.
Now, if we can then just pick up Lord Jenkins' evidence to the Archer inquiry, First of all, his written statement, which is ARCH 0002968. I think I've given you the requisite number of zeros, Lawrence. So we can see statement by the Right Honourable the Lord Jenkins of Roding, former Secretary of State for Health and Social Security, 1979 to 1981. Now, I'm not going to deal with what Lord Jenkins says about his own time in office, but just deal with the issue about documents. Towards the bottom of this page, he refers to his letter to Lord Warner and Lord Warner's response. If we go over the page, we see his comments on the standard lines included in Lord Warner's letter in paragraph 6. And then paragraph 7 deals with his account of his meeting with you. It was not until the 13th of April 2005 that I was able to meet Sir Nigel Crisp and put the whole matter to him. Sir Nigel expressed dismay at the inadequacy of Lord Warner's first letter and at the terms of the background note which had inadvertently been sent to me, and he offered his very sincere apologies for my having been treated in this way. He then went on to explain that there are indeed a large number of files held at the Public Record Office and that it would be necessary for his officials to extract all those files which might be relevant to my inquiry. However, and this was perhaps the most important point to emerge from this meeting, Sir Nigel made it clear to me that all the files that bore upon the issue of contaminated blood products had been destroyed. He went on to explain that there had been a long process of litigation by and on behalf of HIV sufferers, which had culminated in those who were identified as having contracted their disease via contaminated blood being offered substantial sums of compensation. He then said that when this litigation had been settled and the compensation paid, it was felt by the department that there was no longer any point in retaining the files about contaminated blood and that they were accordingly destroyed. He then goes on to record his surprise at this and his difficulty in understanding it. And then he says, Sir Nigel could do no more than express his regret that this had been done, but I was left with a clear impression that it had been done with intent in order to draw a line under what was by any standards a health disaster, not only for the blood transfusion service, but for the NHS generally. Perhaps if I just read the other relevant passages of this document and then come back to ask you for any reflections you have on it. Yeah. If we go over the page, paragraph 9, Lord Jenkins records his impression from a discussion with Mr. Conan, his impression or his suspicion that Mr. Conan might have known more about the destruction of the files than he was prepared to disclose. And then if we go to the bottom of the page, paragraph 13, we can see in the last few lines a reference to Lord Warner in Parliament saying, we regret that the papers were destroyed in error, which was, I think, explained to the noble lord in a meeting with the former Permanent Secretary. And then over the page, Lord Jenkins continues, since this was most certainly not the explanation that had been given to me by Sir Nigel Crisp at the meeting referred to above, I found the Minister's answers deeply unsatisfactory. And then he describes following it up with further questions and communications with Lord Warner. Those all post-date your time in office, so I don't think we need to look further at those. So if we go back to page 2, the heart of Lord Jenkins' written statement on this issue of his meeting with you is at paragraph 7. We've obviously canvassed this already in the questions that I've asked you, Lord Crisp, but is there anything further that you would wish to say in response to Lord Jenkins' statement here as to his recollection of what you'd told him?
Yes, and it's a very specific recollection, much more specific than earlier, in his earlier correspondence with me. I mean, I find it inexplicable that I could have said that, because there was no evidence for that. I didn't know anything other than what I was being told. So I do find it very surprising, but clearly we had some kind of misunderstanding here about what I had said or what I hadn't said. But it's also clear that by this stage he has gone from saying he wanted to know what the reasons were, to saying that he does know what the reasons were and that I'd already told him, which seems slightly surprising. All it really leads me to do is to wish that I had had that meeting with him at the end of 2015 and we could have had it out.
So at the end of 2015?
I don't mean 2015, I mean 2005.
The second meeting that he'd requested?
The second meeting he'd requested, I'm sorry, we didn't have it. And we could have had this out between us rather than in this rather distant fashion. But as I say, I have no recollection of the meeting, so I certainly don't remember saying this. But I find it extremely surprising that I would have said anything like that.
Because of your own lack of memory of the meeting itself, you've relied, I think, to a considerable extent on the background note and the line to take as being what you think
the
you're likely
reasons
to
why
have
I think
said.
I wouldn't have said that, you're quite right, are threefold. One is because in an area where I didn't know much about, which frankly this was an area, I would have relied on what my officials told me. Secondly, it was very clear that, as you say, the knowledge that these files weren't destroyed was not available at the time. But if anyone has any sort of conspiracy theory that somehow I was part of some conspiracy that was hiding the fact that these had been destroyed, well, that sort of rather gives a lie to that, because if the files hadn't been destroyed but had been mislaid in this way and then found again, then I think that's an important point. But the third point is that my officials do not seem to have any record that I said this, nor did they come back to me and say, you said the wrong thing, nor was that recorded in any of this paperwork. So I can only conclude, strange as it is, that something I said led him to think along these lines.
Is it possible, do you think, that your officials may have said things to you, in addition to what's set out really in very short terms in those 3 or so lines of the line to take in the written note, that might have been supplemented in an oral discussion before the meeting with Lord Jenkins, which led you then to say something which conveyed the distinct impression that there had been a deliberate decision to destroy the files?
It's possible. It's possible they could have said something to me. But I look at this, which is a chain of sort of unfortunate, but also, poor practice is what we've seen of a not very good line to take, which turns out in the longer run not even have been totally accurate. Some miscommunications all the way down the line, really. But none of that, and you can see Lord Jenkins in his letters, I think, getting more annoyed as he goes on. So his first one, which I think we haven't seen, but was his reply to whoever it was from the haemophilia group who'd written to him, saying that he'd had on the surface a good meeting with me, and that I was very apologetic, as he repeated in here, and so on, and let's see what happened, where he simply said, he told me that the files had been destroyed. The story then expands later on into a lot more detail, and this is, I think, even more detailed than the last letter we were looking at before we broke for lunch. So I'm not sure. I mean, I suspect he's been getting more annoyed. He's thought more about it. He's talked to other people and so on. But I don't know that, and I'm really sorry that we can't have it out. But somewhere along the line, there must be some misunderstanding, because I simply cannot believe that I would say something that was so obviously not right.
There's a reference here, it's about halfway down this long paragraph, to you explaining that the litigation had culminated in those who'd contracted HIV from blood being offered substantial sums of compensation. Was that your understanding that substantial sums of compensation had been paid?
Well, if I look at these papers, that would be my understanding now, wasn't it? I don't know, I can't tell you the exact timing of this, but there was a compensation scheme, wasn't there?
Well, I don't want to put words into your mouth, Lord Crisp. There was a settlement by payment of sums which it might be questionable to term substantial.
Right, okay.
And a settlement without any admission of liability, and to some extent a disavowalment of any subsequent schemes being compensatory in nature. So, but I don't want to go through what is a very complicated
No, I understand.
Set of different pieces of evidence that you weren't aware of at the time. I'm just wondering whether you think you might have said something to Lord Jenkins that resulted in him thinking that there had been substantial sums of compensation paid.
Well, probably. I mean, I'm sure some of these, I'm sure the discussion was wider than the note shows. So it may have been that, so when that litigation was over and there had been some compensation agreed or a settlement agreed or whatever the language was, some point after that the files were destroyed. I mean, I could clearly have said something like that, but, you know, I really don't know. I really don't know.
And then just lastly then, Lord Jenkins' oral evidence to the Archer inquiry, ARCH 606, please, Lawrence. And if we go to page 12. So we can pick it up page 16, sorry, line 16 onwards, where Lord Jenkins is clearly describing his meeting with you. He says, it was then that Sir Nigel and I remember his words very clearly, and I quoted them in my statement, and then there is the extract from the statement that we just looked at. And then he said the reason was they'd settled the HIV cases, compensation had been paid, and that it therefore had not been thought necessary to keep the files. And I rather hung my further thoughts on that it had been a conscious decision not to keep the files because it was thought there would be no further purpose. Now, again, is it possible that you said something about not being thought necessary to keep the files because the litigation had been settled?
I think that's very unlikely. I think because as you've just demonstrated earlier from the record-keeping requirements, these would obviously fit in as files that should be kept. So, and I think I would have known that. So I think that would be extremely unlikely. But this is also the bit where I rather hung my further thoughts on that. So you can see that he is developing his thinking about what must have happened. You know, it's possibly when he says I rather hung my further thoughts on that, that's not quite as clear-cut as his earlier statement that I had said something, or that in his written statement that I had said something quite as definitive as he said I had said.
And then if we go towards the bottom of the page, he refers to, this is from line 19 onwards, the words Lord Warner used about inadvertent and error. And the top of the next page, he says, I've been unable to reconcile that statement with what the Permanent Secretary told me when I first met him, that it was decided not to keep the files. And then lines 7 to 13, he refers to you being extremely helpful, very apologetic, and says he must have been briefed. Somebody told him that. He would not have invented that. And then says this, I don't know whether you're going to talk to him. Were you approached by the Archer inquiry to give evidence?
I don't remember. I don't think so. Though I see somewhere in this that I was abroad or something, it said.
There's a reference somewhere to you being abroad.
The reference to me being abroad. And so I was probably was, which may have been why I probably wasn't approached. But I don't, in fact, Yeah, I don't know. I don't remember being approached.
I'm going to move from that issue now just to some other matters relating to your time in office. The inquiry knows from evidence it's heard that during the period 2000 to 2006, there were a number of matters of relevance to this inquiry's terms of reference and in terms of its examination of the response of government that was going on. There was litigation against the National Blood Authority, which I know you're aware of from your statement.
Yeah.
Culminating in a judgment from Mr. Justice Burton, and there are some references to it in the documentation. Is that something that you had any involvement with, to your recollection at the time?
No.
Not something you recall being briefed about at the time?
No.
Would you have expected to be briefed about it?
No.
And why is that?
There was quite a lot of litigation going on. I mean, this was a time of, remind me, that was 2001, was it?
The judgment was 2001, yes.
Yeah. So I came into post at the end of, the beginning of November 2000. We had this great, the NHS is huge. You know, it's an organisation it's the biggest organisation in the country. 1.3 million people staff in it. Fantastic range of activity. I would have spent some of that first period mobilising the changes that we wanted to make. So I suspect in that first period, even more than later on, I would have been very much focused on the NHS, and that was what I'd been appointed to do. As I say, I had good people having delegated authority in the Department of Health, in fact, people who were more experienced than me in the areas they were dealing with. So I would have been very focused on getting improvement underway, which didn't really start to come through till 2001. So you can imagine the whole period of 2001, 2002. So the whole period of 2001 was mobilising the NHS towards the new goals, the new ambitious goals. And remember as well that the government had agreed, well, Mr. Blair had agreed in a television interview to increase the expenditure on the NHS to the European average. And that is a massive increase in what was already a massive budget. So this was all focused on how we were going to use that money and make change happen. So it would have been slightly odd if I'd been brought in to any discussion at all around litigation that was about something that had happened some years before, if that's the reason I'd been brought into post. So that would have been very much the focus that we had. Yeah.
Just on the question of funding more generally, and resources available to the Department of Health, we've heard from other witnesses about negotiations with the Treasury.
Yeah.
Was that something that you played a direct role in terms of interaction with the Treasury, either to get the regular amounts of money that were being made available to the department and to the NHS, or specific attempts to get money from Treasury reserves, for example?
Some of that I was involved in, but the main part was played by ministers and their special advisors in terms of doing that. But you're right, that was a big part of that, because that money wasn't available until 2002.
One of the other issues that we know was under consideration by the Department of Health during your time was the question of whether to set up a financial support scheme for those infected with hepatitis C. And the Department of Health line essentially remained no until John Reid came in replacing Alan Milburn and decided yes to what became the Skipton Fund. The documentation doesn't, I think, show any particular involvement from you in that decision making. No. Do you recall having any involvement in it?
No.
And then a third issue that was essentially under consideration throughout that period was the question of whether there should be a public inquiry.
Yeah.
And that's the topic I just wanted to pick up with you next. Again, it doesn't seem as though the question of whether there should be a public inquiry, although it's mentioned in a number of the documents that we've looked at, and you would have been aware that from I think the Jenkins correspondence and with Lord Warner, that campaigners and parliamentarians were advocating, or some parliamentarians were advocating a public inquiry. Doesn't appear to have been something, again, in which you became directly involved. Is that correct?
No, I'm sure I wasn't.
And why was that, do you think?
Well, because I was directly involved in other things. I mean, as I say, with an organisation the size of the NHS, you've got to work out where you add value. So if you're the chief executive, you don't get involved in micromanaging people across the whole. I mean, at this point, all the hospitals and because this was just before most of the trusts became foundation trusts, they were all directly accountable to me. So I actually had the entire NHS system directly accountable to me. So what was the best use of my time and what was the best use of other people's time? And you can't micromanage something the size of the NHS, let alone with the Department of Health added on to it, if I can put it like that. And in any case, the people that I'd got in post in the Department of Health who were dealing with those issues were extremely experienced, capable people whose judgment, frankly, I would have valued better than my own on these matters.
Now, there were some matters dealing with inquiries or the results of inquiries and investigations in the health service that you were dealing with. And if we just look at your statement at WITN 3996026, so this is your second statement at Lord Crisp, page 5. Having set out in the first two paragraphs a number of the issues with which you were dealing in relation to the NHS, you say this at paragraph 0.12. I also had to respond to external and unexpected events, including the exposure of Dr. Shipman's activities, the deaths of children in Bristol Heart Hospital, and the Alderhay pathology scandal, where children's body parts were retained by pathologists without parental permission for research. The DH was dealing with all of these during my tenure. And then you say this: I was involved in all of these because they had widespread implications for the NHS. In the case of Dr. Shipman, for example, there was work to do in improving death certification and ensuring scrutiny of single-handed GPs. For Alderhay, this involved a review of practices in all pathology departments, as well as managing major change in Alderhay itself. Does it follow that the fact that the issue of a public inquiry into the infection of thousands of people with fatal or potentially fatal viruses through their NHS treatment was not regarded by the department as something with widespread implications for the NHS?
No, it doesn't. The question of a public inquiry, well, I wasn't involved in setting up any of these public inquiries, so at the equivalent stage, I wouldn't have been. If there had been a public inquiry and the public inquiry had come out with recommendations, then I would have been involved in it. I was also involved, at least in a budgetary level, in providing some of the additional finances, because I approve budgets, for recombinant treatment and so on. So I would have been involved with some of today's issues in the NHS, but there would be no way in which I would have been involved in the early stages of, I mean, I did give evidence actually to the Shipman inquiry, but on a very small set of issues. But it was the results of those inquiries that I was involved in that had widespread implications. So there's no sense that I would want to devalue. And as I said at the beginning, I mean, I understand that there are thousands of people involved, and I understand that thousands of people's lives have been affected, and that this is, this is extraordinarily difficult for people.
Was there any? We can take that down, Lawrence. Thank you. But was there any? As far as you know, any internal guidance or policy or criteria as to what might lead to the establishment of an inquiry, public or not?
There was, as I recall it, a small inquiry team who I have seen referred to somewhere in this as giving people advice as to how to handle. You won't be surprised to know that there would have been a lot of requests for public inquiries, but I don't think there was a clear threshold beyond which one said this needs to be a public inquiry as opposed to an internal audit. But there were people here with an awful lot of experience.
Now, you've said in your statement, rightly, that the government position, that, as it were, you inherited, the existing government position when you took up your post, was that there should not be a public inquiry. Yes. And you've exhibited, for example, to your statement, a couple of letters from the Prime Minister, Tony Blair, to that effect. I'm not proposing to look at those with you. But it was, as I think you described it in your statement, an established Department of Health position by the time you came to the department in late 2000.
Yeah.
Do you have any recollection of how and when it came to your attention that was the departmental line?
That was a departmental line? About this specific issue? Yes,
about this specific issue.
No.
Now...
Well, sorry, it was probably in that briefing, wasn't it?
There are certainly references to it in the documentation. That was
probably the time when I would have become aware of it then, yeah.
Now, again, there are a number of occasions then during your time in office when the issue of a public inquiry is raised either in Parliament or through MPs or through campaigners writing to ministers and ministers responding and so on. Yeah. You've helpfully set out in your statement chronologically an account of a number of those documents. Again, I'm not going to go through them because, as I read your statement, the majority of the documents didn't come to your office. Right. But there are two, in particular, reasons given in those documents, and you refer to them also in your statement, for not holding a public inquiry. They're not the only reasons given, but there are two which feature, I think, repeatedly. One is the suggestion that all the information is in the public domain, or that all the facts are known in the public domain. Mm-hmm. Would you accept that in order for the department to be asserting that, whether it's an advice, whether an advice to ministers or asserting it publicly in a response to campaigners or parliamentarians, the department would have to have a decent understanding of what the relevant facts were, and then would have to have assured itself to some extent that those were facts that were publicly known?
Yes, I would think so.
Did you ever see any evidence of the inquiry of the department having done that, or did you only ever see the passing references in the material to...
I'm sure I would have only seen the passing reference. It wasn't, and again, this is no disrespect to the people who are infected and affected, but it simply wasn't one of the areas that I was focusing on, and I wouldn't have done that.
But is this fair, that as someone who held the rank of permanent secretary, so the top civil servant in the Department of Health for 6 years or so, you would expect that if the department is saying all the facts are in the public domain, that they would have a proper basis for doing so?
I would, and nor do I seek to evade accountability, because these people were accountable to me in the last resort. Yeah.
One of the other reasons advanced in some of the documents, and you've referred to it in your statement, for not being a public inquiry, is the government doesn't accept that any wrongful practices took place. Now, and it might be said that's the government marking its own homework, because the purpose of a public inquiry is usually to establish if there were wrongful practices, and government's not always completely forthcoming in identifying wrongdoing on their own part.
Yeah. The trouble with that argument is that might suggest that we should have a public inquiry on almost everything. I mean, one of the things I inherited was a waiting list for cardiac surgery where 4% of the people on the waiting list died before they got into hospital. Now, you might ask, shouldn't you have a public inquiry as to how that happened? how we could get to that. We didn't. My focus was on making sure that we actually got a waiting list for cardiac surgery that meant that people at least had a chance, they at least got into hospital. They didn't die while they were on the waiting list. So I think there are differences, and I know you asked me later if I thought there should have been a public inquiry on this, and do you want me to say something on that now?
We can deal with it now, absolutely.
Yeah, well, I mean, I think, as I said at the beginning, looking at the 40 years plus of this whole story, I can see that the system simply hasn't treated the people who are infected and affected well. You know, there are a whole series of things down the 40 years which seem not to have been right. And I would have thought that if only we could have had a public inquiry somewhere round about the sort of mid-80s or 1990s or something like that, when you were close enough to events to understand what was happening, but you could have also picked up on the entirely understandable, emotion that we would all have had of people wanting to know what had happened, and it would have. There was enough there, it seemed to me, to warrant whatever the threshold was, to warrant a public inquiry at that stage, if that was the best way to handle it. Now, I'm not an expert on public inquiries, and I understand that you can do things in different ways, and a public inquiry is not always the answer. It does depend what the question is. But my view would have been sensible to have tried to do something then.
I think just a couple of documents that I wanted to invite your comment on the issue of, again, what the department was saying in relation to public inquiries. Not because they're documents that you saw at the time, but really to invite your reflections on them as permanent secretary at the time, and conscious that you say ultimately you accept responsibility, albeit that you didn't have any direct involvement in the decision making. The first is DHSC 004139_177. This is just by way of introduction, because the actual text I want to ask you to look at is an appendix to this. But this is a submission from Bryony Enser to Yvette Cooper, July 2001. So she was the then Parliamentary Under-Secretary of State for Public Health. Yeah. And we can see she's been asked to provide, Ms Enser's been asked to provide a position paper to Yvette Cooper, following the judgment of Mr Justice Burton in the National Blood Authority case. If we go to page 4, we'll see a series of options set out. Yeah. And option 2 is public inquiry plus lump sum and hardship fund for haemophiliacs infected with hep C by blood. And then it said these options are set out in full in the attached options paper. And it's the options paper I just want to ask you something about. It's DHSC 002756_025.
Before you leave this document, I think this is the document I'm thinking of. Can we just look at who it's copied to?
Yes, we see that on page 5. Yeah. So it's at the end rather than the beginning.
Oh, right, okay. So I think this one is, right, it's not the one I thought of, but I was just checking that there were some very senior people in there. So the Chief Medical Officer, Private Office, the Deputy Chief Medical Officer and others were involved in this. So this would be a sort of example of what I was saying, of very senior people with good experience being engaged in these discussions, even if I wasn't. These people had more experience than me, candidly.
Yes, and it was going to the Secretary of State's private office, as we see from the top, to Sally Sinclair.
You understand the point I'm making, that this is a good example of how things should have been handled.
And then the options paper is referred to as at DHSC 0020756025. and if we just go to page 3, it's just the for and against arguments for a public inquiry I wanted to explore with you.
Right.
So this is option 2, public inquiry lump sum and hardship fund for all haemophiliacs infected with hep C by blood. And I'm not going to ask you anything about the lump sum and hardship fund issues because we've explored those with other witnesses in some depth. But the for argument would satisfy lobby, would establish all the facts. Now, the would establish all the facts is clearly referring there to a public inquiry. And then the against arguments, I think the first 2 deal with the issue of financial support. The third repeats the assertion that relevant facts largely establish information in the public domain. The next 2 points deal with compensation. And then the last 2 points in that box deal with the public inquiry, lengthy time period for inquiry to report. And then this, public inquiry would raise the profile of potential no-fault compensation at a time when litigation in the NHS is an increasing problem. Now, I flagged that up, and I just want to tell you briefly, in summary forms, evidence that Jeremy Hunt, obviously a rather later Secretary of State for Health, gave to this inquiry, which was to the effect that his understanding was that a reason or the reason not to hold a public inquiry was the fear or concern that it would lead to the payment of compensation. Would that be a proper reason, in your view, not to hold a public inquiry, if that were the reasoning?
Not in itself, obviously not in itself. And, just by reference to some of those other inquiries, the Shipman inquiry where a doctor murdered 200 or 300 people, I can see no reason why you wouldn't hold a public inquiry, even whatever the costs were involved in it. So I don't think in as much of itself, but what civil servants would properly do, and what I think they're doing here, is drawing attention of ministers to the fact that there are costs involved. And the dynamic, as you will well understand, but again, perhaps for the record, as it were, is that ministers will always be pushing for things to happen, and civil servants will have to be saying, you don't understand the consequences, including money. So I see this as a list, which includes things like lengthy time period for the inquiry to report. Public inquiry, I would have also put in an against on this, is the opportunity cost, because if people are tied up in an inquiry, they're not engaged in something else. Yeah? So I think those are the sort of things I'd expect to see on a list like this. But I don't think there's any suggestion in this particular paper that that would be an overriding reason for doing it. As I say, the Shipman one, I cannot imagine any circumstances in which you wouldn't hold a public inquiry into how a GP could kill at least 200 people.
And then,
murder.
If I can ask you to look at one other document, again, not a document you'd have seen at the time, DHSC 0042461_064. This is March 2002, 22nd of March 2002, from Jill Taylor. It's addressed again to PSPH, so the Parliamentary Under Secretary of State for Public Health. We can see a number of recipients there. I think you identify in your statement Mary Mahoney as being branch head in the Public Health Directorate and relatively senior.
In what, sorry?
The Public Health Directorate is your statement describes her as being branch head of.
Right, okay.
But in any event, not I think copied to your private office as I understand those list of recipients.
It doesn't look like it, no.
But in any event, we'll see it's a request for it's a response to a request for advice following receipt of a letter dated the 22nd of February from Carol Grayson, who was a prominent was a prominent campaigner. Again, I'm not going to go through the detail of it. Over the page, it raises a number of questions, or addresses a number of questions raised by Ms Grayson and by Lord Owen.
Yeah.
I just want to ask you about something that's in paragraph 15, so page 3. Paragraph 15 says this: "We've concerns that Ms Grayson's evidently obtained government documents from the 70s, 80s, and is basing some of her arguments on information gleaned from these papers. Officials have looked at some files from that period to establish how the money allocated by Lord Owen was spent, and papers on this issue have been passed to the Haemophilia Society. However, given pressures on time and resources, we have not looked in detail at the decisions made during that period, an exercise requiring several weeks of work. We've therefore not responded to some of the detailed questions in Ms Grayson's letter, which are partly based on those documents. We recognise that this is not a sustainable position and will provide further advice on handling shortly. Now, it's that sentence about not having looked in detail at the decisions made during that period, and that being an exercise requiring several weeks of work. If the line to take being promulgated by the Department of Health was all the irrelevant facts are in the public domain and there are no wrongful practices on the part of the government, it might be said, how could the department make those statements if, as this document suggests, they hadn't looked in detail at the decisions made during that period? Maybe that's limited to decisions relating to self-sufficiency, but in any event, do you have any concerns about the possible tension that there might be between those lines to take that the department promulgated and what is revealed here?
Well, I'm not sure if my concerns would be about the tension between those two, because the line to take was about information, wasn't it, rather than about decisions taken? Is that the line you're talking about?
Well, there are two aspects of the lines to take in relation to no public inquiry. All the relevant information is in the public domain and no wrongful practices.
Oh, I see. Okay, yeah. Well, there's obviously a tension between those two, yeah.
Can I then, we can take that down, can I then just ask you just a little more generally about whether there is a long-established departmental position, such as the position in relation to a public inquiry, but it might also apply to decisions about not paying compensation and so on. How can those be, and how should they be, challenged or reviewed or overturned? What can be done to prevent something having been decided effectively then staying as if written in stone?
Well, I think there are probably two or three things here. One is a management process within the branch or the division. Presumably, ideally, each branch should be carrying out a performance review with their individuals involved within that branch on a regular basis, and there would be opportunity within that to review that. Secondly, the availability of information and making sure the relevant information is brought to people's attention. And that, again, I think is one of the system issues that are here, whether the department at that time, I don't know about now, had a sufficient way of making sure all the right information was in the right place. So that people knew about them at the right time. But the way in which lines to take would be challenged, other than through those sort of, if you like, routine mechanisms, would firstly, if there was some new evidence came in that was clear and that then challenged the line to take, then that should be picked up, presumably at official level. Secondly, if there was a political change of some sort, like a new government, like even a new Prime Minister. I mean, we will all understand that lines to take around Whitehall are being challenged as we speak, with new ministers coming into new departments. And in some ways that might be the biggest time with a change of minister or a change of, and each minister will have had within our six at any time, they had divided up subjects between them. So we saw somewhere earlier, didn't we, that the public health minister was the one who had blood, who had the infected blood issues. And when they take up their post, that's an ideal time to be reviewing the lines to take, because indeed they will be being briefed on them. And then I guess the third thing is if something happens, if there's some, not evidence, but some external thing that happens that really forces the issue in whatever way. So those would be the sort of reasons and the sort of ways that change can be brought about.
The NHS is now subject to a prescribed extent to a duty of candour.
Yeah.
Do you have any views as someone who's worked both in the NHS and in the department on the value of there being an equivalent or similar duty of candour imposed on civil servants and government ministers?
Well, I do think that there are a number of things that the department could learn from the NHS, actually. And I think I was going to say let me talk a bit about where I think the system failures
yes.
are. I suspect you've had Jeremy Hunt's evidence. Jeremy probably talked to you, or talked to you, Sir Brian. Not sure where I should look, forgive me, about the developments over the last 20 years, really, in patient safety and quality, and how there are some very clear things that come out of that. One is that almost always when things go wrong, well, no, always when things go wrong, there's a system element to it, and almost always it's the biggest element. There may be individual wrongdoing, but actually it's the system. Associated with that is far greater transparency in terms of working with patients, much more closely with patients, and you can imagine how you need the equivalent within this environment. There may be the equivalent within this environment in the Department of Health now, I don't know. You can also see that there is a bit about a duty of candour, which might be good to. Forgive me for just checking. But the other thing is that in addition to a duty of candour, what you really need is a patient safety culture. You know, they can have rules and regulations, but rules and regulations aren't always followed. And it's actually the question of having a patient safety culture. And if I were looking at this today in the light of what I've seen from the material that your inquiry, Sir Brian, is looking at, I would be thinking about asking if those learning about that has happened in the NHS around all those areas, not just the duty of candour, but the patient culture, the ways of engaging patients, have been fully learned and translated into the department. Now, I think that the department during my time, and I'm marking my own homework here, but as an outsider, I think they handled a lot of very good policy development. I think there's some terrific examples. I gave you one earlier of a massive change in how prescribing was done, but there were many others, including some of those ones that came out of those earlier inquiries. But one of the things that comes obviously out of all of that is the question of continuity. You mentioned it originally, and others have obviously mentioned it. I think my list had 13 or 14 ministers on it who had some kind of engagement in my 5 years, let alone the other 35 years, as it were. But there's also a continuity of priorities, because as priorities shift, then resources shift, and areas get different levels of sort of attention. And there's also a continuity of knowledge. And one of the big differences here is, and this is the reason why if you're going to have a public inquiry, for goodness sake, have it early, because it's hard to sustain real focus over a 40-year period. And that's where I think, the system just hasn't worked for that. It's worked very well for those other examples I gave you, for the sort of 3-year period or the 5-year period when, everything was in focus, people were looking at what was there, the same people broadly were in position within that time. So I think there's something there about if you know that something's going to go on beyond 5 years, and then actually some special precautions or something needs to be taken to make sure that there is that ability to achieve that continuity. Because this has just been bounced around from one minister to another, hasn't it, for years, and that's not an individual issue, that's a system issue.
And just going back to my question, I think you've answered it.
Sorry.
No.
Yeah.
I think you've answered it in what you said, but I just want to check. In terms of there being some kind of, whether you call it a duty of candour or an obligation to be transparent, that applies not just within the NHS, but applies to central government and specifically to the Department of Health. Yeah. Obviously, there may be subject to certain exceptions, but in broad terms, would you support that?
Yes.
There's just a couple of other...
I'm actually slightly surprised there isn't one.
Just a couple of other topics, Lord Crisp. We've seen reference to the report that was being done into self-sufficiency. That was an internal...
Into?
Self-sufficiency.
Oh, yeah.
The internal report commissioned in, I think, 2002. Yeah. Report finalised, published in 2006. Now, again, it's referred to from time to time in the material that we've looked at today, but the documents, which I won't take time going to, and your statement refers to, indicate that your office became involved at a relatively late stage, dealing with questions of when it was going to be finalised, and a timescale in relation to that. Yeah. Do you have any knowledge yourself of why it seems to have taken 4 years to produce that?
Well, only what I've read in the papers, but it is a good illustration of what I just talked about. It was actually commissioned by a minister who then left, and it then went to, at some point within that, the official who was dealing with it was doing other things and therefore didn't pay attention to it for quite a long period. So it was exactly the sort of circumstance I'm talking about. So that something that should have taken a year at best took 3.
And then the final matter I wanted to ask you about, it goes back to the terms of a letter that we looked at earlier. WITN 399619. Sorry, Lawrence. WITN 399619. My apologies. So you'll recall, Lord Chris, we looked at this minute from Zubida Sidat to you, November 2005. Yeah. Bottom of the page referred to the second set of documents understood to have been destroyed, the documents relating to the Advisory Committee on the Virological Safety of Blood, and there's reference there to the internal investigation. And if we go over the page, I read aloud, as you'll recall when we looked at it, the passage that Ms Sidat sets out from the internal audit report. Just wanted to ask you about how this then gets presented in the letter that was drafted for you and which you sent. It's page 7 of this document. And it's the penultimate paragraph beginning, officials have also established. So this letter sets out, first of all, this is 4th paragraph, 4th line down, and your understanding that a decision most probably made by an inexperienced member of staff was responsible for the destruction of a number of files. It's then asserted that this was not a deliberate attempt to destroy documentation, and then it's asserted that it's very unfortunate that the staff member at the time was not fully aware of the significance of the files and the possibility of future litigation. Now, look, it's my understanding from the internal audit report, and we can go to it if necessary, but is that was unable to identify the actual member of staff who had decided that these documents should be destroyed. And so there's no testimony or admission or explanation from any particular individual about what their thinking was or why they did or didn't do it. It wasn't even known. And that there's if I can put it this way, an assumption made in the report that some experienced members of staff having left, it must have been done by an inexperienced junior member of staff. But that's an assumption rather than a factual finding on the basis of concrete evidence. So it might be said that what's being set out here goes too far in making positive statements about how the decision was taken and what the position of the staff member was.
Yes, I think that's probably right. An inexperienced member of staff was probably made by, so it wasn't clear who'd made the decision, and therefore you can't absolutely determine. I think there's a point here about. Well, there are three things here. Firstly, of course, this was deliberate in the sense that an individual deliberately did something. To be pedantic, it wasn't deliberate in the sense of being departmental policy to do this. I think I could safely assert that. But I suppose you could suggest that still leaves room for a deliberate attempt by somebody to destroy documentation. It doesn't completely rule it out. But yes.
I think, if I may, Lord Chris, the problem is exactly the same in a different context of the word we looked at earlier, the error, with no one identifying what the error was. The decision to mark files for destruction is plainly, in itself, a deliberate decision.
Indeed.
It doesn't answer why that particular documentation should be destroyed. And without knowing who did it, you can only speculate. You just don't know, do you?
And I think that's absolutely right. The implication that is drawn out in the report, as I recall it, was done by somebody who thought they were doing the right thing. But you're, of course, absolutely right. It could be done by somebody who thought they were doing the wrong thing.
Without knowing who it is,
yeah.
Then the assurance that thought they were doing the right thing is something based on nothing, because it's an assumption. It's not actual evidence from that person.
Yeah, I would have to look at the audit report again just to make clear, to try and understand presumably they had narrowed it down to a small group of people who might have done it, which might give you some indication. But of course, logically, you're entirely right, Sir Brown.
I think we shall hear further evidence about this later on this week, so it would be wrong to rush to a judgment on it. But I've expressed my concerns about the words, at any rate, as they currently appear. Yes, thank you.
So those are the questions I have for Lord Crisp, and it coincides with what would ordinarily be our afternoon break in any event. So if perhaps we could take the break, and this is the opportunity for core participants or their representatives to suggest any further lines of questioning arising out of Lord Crisp's evidence.
Lord Crisp, you may well be familiar with the process, but if let me just explain in much the same language as Ms. Richards has used what happens now. The Inquiries Act permits those who are core participants represented by legal representatives to have those legal representatives suggest questions to counsel for her to ask you. Plainly, we have to give an opportunity for that to happen, and there's no sensible opportunity until the questions that she has of her own have been fully asked. And so to give that, we have to give a reasonable amount of time for that to happen. So what I'm going to say is we won't meet again until 3:45, but we may not meet then. So we won't meet before 3:45. We may meet after that. It depends how many questions there are. And I can't tell you quite how long you will be detained. It depends how many questions there are, how long they take to answer.
Thank you, Sir Brian. I will be invited back anyway, will I, at some point then, just so that I can perhaps make a concluding comment or two.
Oh, yes, of course.
Yeah, good.
At the very end of the proceedings, Ms. Richards will say to you anything you would like to add,
Yeah,
and you are free to say anything that you would wish to say. We want to hear what witnesses have to offer.
yeah, good. Thank you.
So you'll have every opportunity to do that in exactly your own words.
Thank you.
And not before 3:45.
Thank you, sir.
You'll be told if there's any delay beyond that, as will indeed those who are in the hearing room.